Good afternoon, everyone, and thank you so much for joining us for this webinar on the UK legal landscape after EU exit. My name's Eleonor. I'm a barrister and director in the privacy team of Field Fisher, based in London. I advise on all aspects of GDPR compliance. Prior to working at Field Fisher, I was a UK government lawyer. I was the lead lawyer for some of the legislation that we're going to be talking about this afternoon, the European Union Withdrawal Act 2018, and I also worked on the UK EU Withdrawal Agreement and the framework for the future relationship. I'm absolutely delighted to be joined by two colleagues this afternoon. I'm firstly joined by Indira Rao, who's a former government lawyer as well, now working as counsel for EU and international law in the House of Commons. So very warm welcome to you, Indira. Thank you so much for joining us and sharing your thoughts and expertise on all matters relating to EU exit. And I'm also delighted to be joined by my colleague Olivier Proust, who is a partner in the privacy and technology team in Brussels, and I think is going to give us some really interesting insights on EU exit from a Brussels perspective. So thank you so much for joining this afternoon. So moving on to how we're structuring this webinar session. We're going to be looking at 4 new sources of law in the UK since the end of last year and the complexity that that has brought to the UK's legal system. And then we're also going to be looking at the future EU-UK relationship. By the end of the session, you should be better able to explain how the UK's legal landscape has changed since the end of last year and the new developments that we're likely to see. So I mentioned the new sources of law, and they're set out here on this slide. And depending on what area you advise on, the pie chart here in the centre could be shifted one way or another, because the 4 elements of law that are new in the UK's legal system are firstly retained EU law, then we have new domestic frameworks, then we have the withdrawal agreement, and then we have the trade and cooperation agreement. And we're going to go through those and highlight some of the important features of them, and we'll go through them in that particular order. So coming first to retained EU law. Now this is a form of domestic law, new domestic law in the UK's legal system. And on the slide, I've set out the legislation that deals with retained EU law, the European Union Withdrawal Act 2018. What problem did the European Union Withdrawal Act 2018, or the EUA for short, try to solve? The UK was an EU member state for 47 years, and so a huge swathe of the UK's statute book came from the EU. And at the point at which EU law ceased to apply to the UK, there could have been a huge gap opening up, because so much of our statute book, so much of our economy was regulated by EU law. So how did we solve in the UK that potential gap in our statute book? The solution was provided through the European Union Withdrawal Act 2018, the EUA. So what it does, in a nutshell, is that it saves EU law, which applied directly in UK law immediately before the end of the transition period. So that's the end of last year, the 31st of December 2020. So the law which applied directly in domestic law was, for example, EU regulations, such as the General Data Protection Regulation, but also articles of the EU treaties, such as Article 157 of the Treaty of the Functioning of the European Union, which deals with equal pay between men and women. So that law, which applied directly in our domestic law, needed to be saved in order to create continuity, in order to ensure that those gaps that I've talked about didn't appear. So what we did was we turned EU law that applied to the UK into domestic law at the end of the transition period. And the other thing that we did was that we had a large proportion of the statute book also implementing EU obligations, so primary legislation implementing EU obligations, such as the Equality Act 2010, but also an awful lot of legislation made under the European Communities Act, which was the main piece of legislation which implemented EU law in the UK's domestic legal system. So all of that domestic law, which implemented EU rights and obligations, was also saved. Another example is the working time regulations. And that body of law which applied directly in UK law and domestic law which implemented EU obligations, was named Retained EU Law. And what did Retained EU Law do? Well, it created continuity and certainty at the end of the transition period because, as I said, so many areas of the UK economy were regulated by EU law. So saving that legislation, those standards into domestic law, created certainty about what the law was in the UK once EU law finished applying. So how do you interpret retained EU law? Well, the old EU methods of interpretation still apply to retained EU law. So, for example, looking at the legal basis of an instrument that we've saved, a regulation perhaps, that's still applicable. Looking at the recitals of the legislation, all of those things which give continuity and certainty. So those EU law methods of interpretation still apply in the UK domestic legal system. And the other thing that we needed to do in order to create continuity of meaning for retained EU law was to save the case law. So we have retained EU case law, so the judgments of the Court of Justice of the European Union, which were handed down before the end of the transition period, so before the 31st of December 2020, also apply in UK domestic law and are binding on UK courts. That's the starting position. And also domestic case law, which interprets EU rights and obligations, is also saved. So in our domestic law still, we have references to the supremacy of EU law. So the supremacy of EU law still applies to how you interpret retained EU law. We still have the concept of direct effect in order to create that continuity, and also indirect effect or malleasing, the requirement to read domestic law in light of the directive which it implements. Retained EU law wouldn't work though if we just left it on the statute book, essentially as it was when the UK was an EU member state. So we have extensive powers in the EUA in order to amend retained EU law to make it function as domestic legislation, as standalone legislation in the UK's legal system. And what the government has done, as well as some regulators, is to bring forward so-called EU exit regulations, and there are about 600 of them made, and they make these amendments to retained EU law to make it function as domestic legislation. So an example which is quite often used is that references to the European Commission, where the European Commission was responsible for regulating a particular area, have now been changed either to a UK regulator or perhaps to the Secretary of State. So those sorts of changes have been made. And the other changes that we've made is to remove some of the cooperation mechanisms that are contained in EU law such as in the context of data protection. The European Data Protection Board meets to provide consistency of approach and interpretation in relation to the regulation of data protection, and the UK regulator is of course no longer part of that system of coordination, and so those provisions that dealt with that system of coordination have been removed from retained EU law. But it would be to overstate things to say that everything has essentially remained the same, because there are some really significant exceptions in retained EU law as well. So I mentioned that the supremacy of EU law has been saved, and that applies for the law which came about, if I can put it that way, during our EU membership. So the statute book is interpreted in the way that it was before. So the supremacy of EU law applies in that context, but it doesn't apply to new frameworks which have been brought forward to legislate for the UK's post-exit economy, as it were. So the supremacy of EU law is limited in terms of how it applies, and it doesn't apply for new frameworks. Direct effect has also been limited. So you could rely on the direct effect of a directive, potentially if a court had said that that particular directive had direct effect before the end of the transition period, but you wouldn't be able to make novel arguments about direct effect of directives. So that's another example of where things have changed. Frankovich damages have also been taken out of domestic law. They don't apply. And quite significantly to some, not so significantly to others, and perhaps we'll discuss that later on, the Charter of Fundamental Rights is no longer part of the UK's domestic framework. The position that the UK government always took was that the Charter simply labelled or codified, set out a list of rights which already existed in EU law. So there wasn't any substantive effect by having the Charter of Fundamental Rights. So it didn't matter if you didn't retain it. Others say actually it does have a substantive effect. So that is an interesting change, which may bring about some divergence perhaps between the UK and the EU systems. And also, the general principles such as proportionality can no longer be used as a basis for a claim. So those are some exceptions and changes which have come about since the end of the transition period. So that's an overview of retained EU law. And now I'm going to move on to look at the next part of that pie chart that I showed at the beginning and look at new domestic frameworks. So this here is the preamble to a new post-Brexit piece of UK legislation, the Immigration and Social Security Coordination EU Withdrawal Act 2020. So that creates a new framework to regulate immigration in the UK after the end of the transition period, where the principle of free movement, which we had under the EU treaties, no longer applies. Some further examples here are set out. The Agriculture Act 2020, setting out new frameworks for the regulation of that particular sector. The Internal Market Act 2020, which was relatively controversial when it went through the House because it had those provisions relating to the Northern Ireland Protocol, which have now been removed or no longer exist. They were in the bill but not in the Act. But this legislation essentially regulates the UK's internal market and ensures that there's a free flow of goods within the UK. And finally, the Immigration Act, which I mentioned earlier. So there's some new domestic frameworks which are in place now to regulate the UK economy after the end of the transition period. And now I'm going to hand over to Indira to look at the withdrawal agreement.
Thank you very much, Eleanor. Good afternoon, everybody. I'm now going to move on to the next slice of the pie, as it were. So the withdrawal agreement is an agreement between the UK and the EU, which sets out the terms on which the UK left the EU. The agreement creates rights and obligations between the UK and the EU on the international plane. In the UK system, domestic legislation is needed to give the UK the powers it needs to fulfil its obligations under the agreement and to give individuals the rights that the agreement says they should have. So the agreement has been implemented in domestic law by the EU Withdrawal Act 2018, which Eleanor mentioned, the EU Withdrawal Agreement Act 2020, and regulations made under those acts, which are a form of secondary legislation. The rights in the withdrawal agreement, as they have been given effect in domestic law, form a new body of law, which is referred to as relevant separation agreement law. And relevant separation agreement law takes precedence over domestic law, including retained EU law. So, for example, there's a provision in the EU Withdrawal Act 2018, which says that the UK courts can no longer refer cases to the Court of Justice of the European Union in Luxembourg after the end of the transition period. However, this is subject to relevant separation agreement law. And there's a provision in the withdrawal agreement which says that UK courts can refer cases to the Court of Justice where they relate to the citizens' rights part of the withdrawal agreement. And this can continue for 8 years after the end of the transition period. So this provision from the withdrawal agreement takes priority over the provision of the EU Withdrawal Act 2018. So moving on to how the withdrawal agreement is structured and what exactly is in it. Well, it's made up of 6 parts, and it's followed by a series of protocols and annexes, which are an integral part of the agreement. So I'm going to start by looking at parts 1 and part 6 together. Part 1, as you can see, deals with common provisions, and part 6, which is on the next slide, deals with institutional and final provisions. I'm going to look at them together because they both apply across the agreement as a whole. So part 1, for example, sets out definitions that apply to the whole agreement. It includes obligations of a general cross-cutting nature. So, for example, the parties commit to carrying out their obligations under the agreement in good faith. Article 4 of Part 1 is a particularly important one. It says that the provisions of the withdrawal agreement are to have the same legal effect in the UK as they have in the EU and its member states. So this means that the principles of supremacy and direct effect apply. And as I mentioned earlier, the EU Withdrawal Agreement Act gives precedence to the withdrawal agreement provisions over domestic law for this reason. I'll now look at part 6, which also applies across the whole agreement. It deals with the institutional framework and with dispute resolution. The agreement establishes a joint committee which oversees the implementation and application of the agreement. The committee is made up of UK and EU representatives, and it's co-chaired by a UK Cabinet Minister, Lord Frost, and a Commission Vice President, Mr. Šefčovič. The Joint Committee is tasked with taking specific decisions which bind the parties, and has a number of other powers which are set out in the agreement. So, for example, it can correct errors and omissions in specified parts of the withdrawal agreement. There are 6 specialised committees which sit below the Joint Committee, each covering a part of the agreement. So, for example, there's a specialised committee on citizens' rights. Technical issues are discussed in these groups and they can be referred up to the Joint Committee. As for dispute resolution, this has had some media attention recently because the Commission has invoked the withdrawal agreement dispute resolution process. There are 2 types of dispute resolution in the withdrawal agreement. There's one which applies to the agreement generally, and there is one which is specific to the Northern Ireland Protocol, which we'll come on to in a second. So the main dispute resolution mechanism in Part 6 starts off with consultations between the parties in the Joint Committee, where they try to resolve the matter relatively informally. If that's not successful, a party can refer the matter to an arbitration panel, and that's made up of independent arbitrators. And I just thought I'd say a bit about how the panel is put together. So it's a joint committee which draws up a list of 25 arbitrators, 10 chosen by the EU and 10 chosen by the UK, and 5 are jointly chosen by the parties, and from that pool of 5 a chairperson is chosen. So when a particular specific panel is constituted for a specific dispute, the UK and the EU will each choose 2 arbitrators from the list, and the panel itself will then choose the chair from the list. If a dispute raises a question of EU law, then the arbitration panel has to refer that question to the Court of Justice. The Court of Justice will then give its ruling, which the arbitration panel will apply to the dispute before it. In terms of remedies which are available, a lump sum or penalty payment, i.e. financial payments, can be imposed for a breach. And in the event of non-compliance with the panel's ruling, the winning party can suspend obligations arising from the withdrawal agreement, except in relation to the citizens' rights part of the agreement. There's also a link here to the Trade and Cooperation Agreement, which we'll come back to later. The second type of dispute resolution, as I said, is specific to the Northern Ireland Protocol, and we'll turn to that in a moment. I'll now touch on Part 2 of the withdrawal agreement, which covers citizens' rights. In essence, it safeguards the residence rights of EU nationals living in the UK at the end of the transition period, and of UK nationals living in the EU at the end of the transition period. But an EU national coming to work in the UK for the first time after the end of the transition period would be subject to the new immigration regime, which Eleanor mentioned. So you can see the interaction between the withdrawal agreement and the future frameworks there. The third part of the withdrawal agreement covers so-called separation provisions. So in essence, this deals with processes that have started under the EU system and are ongoing as at the end of the transition period. And Part 3 explains how these processes will be concluded. So to illustrate, there's a provision in the withdrawal agreement in Part 3 which deals with cases against the UK before the CJEU, which were ongoing at the end of the transition period. The agreement says that those cases are to continue to judgments under the EU system. So the Court of Justice gives its judgments, and then that judgment of the CJEU is binding on the UK. Moving on to Part 4, which is on our next slide. Part 4 deals with the transition period. No need to say too much about that because the transition period is now over. But in a nutshell, what it did was to provide that EU law would continue to apply to the UK until the 31st of December 2020, even though the UK was no longer a member state and no longer participating in the EU institutions. When you're looking at the UK legislation on retained EU law, one point to bear in mind is that the withdrawal agreement uses the term transition period, but the UK legislation uses the term implementation period, but it's exactly the same concept that we are talking about, just a difference of terminology. Then moving on to Part 5, this deals with financial provisions, and what this sets out is a methodology for calculating the sums that are owed by and to the UK as a result of exit. So we've covered Part 6, so I will now just say a little bit about the Northern Ireland Protocol. So the operation of the protocol has been in the news a lot recently. It was designed to avoid a hard border between Northern Ireland and Ireland. It was also aimed at protecting the EU's single market in goods, and also another aim was to facilitate unfettered access for goods between Northern Ireland and Great Britain. So under the protocol, Northern Ireland remains part of the UK customs territory. But the EU Customs Code and EU rules relating to goods, state aid and other areas continue to apply to Northern Ireland. And where EU rules apply to Northern Ireland, EU methods of enforcement still apply too. So, for example, the Commission can still bring infraction proceedings against the UK for breaches of these provisions of the Northern Ireland Protocol, and the CJEU still has jurisdiction. So the other protocols on sovereign base areas and Gibraltar, I think people are less likely to come across in practice. So I won't go into any detail in relation to them. And mindful of the time, I'll move on to the Trade and Cooperation Agreement. So this is the front cover giving you the formal name of that agreement. We'll move on to the next slide. So what exactly does a Trade and Cooperation Agreement do? Well, it sets out the new relationship between the UK and the EU. In the words of the agreement itself, it establishes the basis for a broad relationship between the parties. It's implemented in domestic law by the EU Future Relationship Act 2020, and this act went through all its parliamentary stages in one day at the end of last year. There are powers in the Act for ministers to make regulations to implement the TCA. There's also a noteworthy provision in the Act, section 29, which in essence says that existing legislation should be read as if it had been modified to give effect to the TCA. So this was a way of making sure that the UK was in compliance with the agreement, even though there wasn't very much time to make all the necessary changes to domestic law. The Act directs us to read existing legislation as if it did comply, and that's quite a novel and noteworthy provision. So the TCA is currently being provisionally applied by the parties. So this essentially means that the parties are applying the agreement, even though the formal stages, the formal steps for ratifying and bringing it into force have not yet been completed. Provisional application is not uncommon for EU agreements, but it's usually used when the agreement is between the EU and its member states on one side and a third country on the other side. And that's because where you have a so-called mixed agreement, one involving the EU and its member states, each member state individually has to go through its domestic procedures to ratify the agreement. And this normally takes quite a long time. It can sometimes take years. So the agreement is provisionally applied in the interim. But the situation is slightly different in relation to the TCA. It's not a mixed agreement. The member states aren't party to it. It's between the UK and the EU. But the EU has asked for a little bit more time to go through its internal processes, because the agreement needs to be translated into all the official languages, and it also needs to go through the European Parliament, and the European Parliament formally needs to give its consent before the EU can proceed to ratification. So the agreement itself is 1,246 pages long. The main body of the agreement is about 400 pages, and the rest is taken up with protocols and very detailed annexes. A colleague of mine actually weighed the 2 volumes and informs me reliably that it comes in at about 4 kilograms. I'm not going to go through all of it in detail because we don't have the time, and some of it is really quite specialised. But instead, I'm just going to pick out some points of interest and a couple of examples which show how the TCA interacts with the withdrawal agreement. So the TCA has 7 parts plus protocols and annexes. I'll have a look at part 1 and part 6 together. Because together they cover the institutional framework and dispute resolution, which are kind of linked. So as I said at the outset, the TCA provides the basis of the relationship between the parties, and it envisages the possibility of there being supplementing agreements in future, which will come under the TCA umbrella. The institutional framework is a bit more complicated than that for the withdrawal agreement. There's a partnership council at the apex, and its main role is to oversee the operation of the agreement. It's quite similar to the withdrawal agreement joint committee. So you have a UK minister and an EU commissioner as the co-chairs. And the partnership council is tasked with taking various decisions. It can correct errors and omissions, quite similar to what the joint committee can do, set the strategic direction of the relationship and so on. Underneath the partnership council, there's a trade partnership committee, and underneath that trade partnership committee, there are 10 trade specialised committees, each focusing on a particular area. And then there are 8 non-trade specialised committees and 4 working groups which support those committees. So this means that the very specialised issues that are bound to come up can be dealt with at technical level, at official level, and then can be escalated as necessary to the Partnership Council. There's also, as well as all these committees, there is provision for a joint EU-UK Parliamentary Partnership Assembly, and there's also provision for a civil society forum. So this is quite a similar structure to the one that the EU commonly uses in its free trade agreements with third countries. I'll just now say a little bit about dispute resolution. I think the main point to note here is that the dispute resolution under the TCA has no role for the Court of Justice, unlike the withdrawal agreement. There isn't a one-size-fits-all dispute resolution mechanism. It differs, the mechanism that applies differs according to particular areas of the TCA. The main dispute resolution process applies to the trade part of the agreement, but even within the trade part of the agreement, there are some variations. So, for example, as we'll see, the level playing field provisions are treated slightly differently when it comes to dispute resolution. And as we'll see, the law enforcement section also has its own separate dispute resolution. So the TCA says that if a dispute arises, the parties have to use the dispute mechanisms in the agreement. The one exception to that is where the dispute could come under the TCA or it could come under the WTO system, and in that circumstance, the parties can choose whether they use a TCA mechanism or go down the WTO route. So just to say a little bit about the main mechanism, it starts off with consultations between the parties, and if that doesn't resolve the matter, then the next stage is an arbitration panel, and the TCA sets out what happens at each stage, how long each stage is supposed to take. Once you get to a decision by the arbitration panel, the question of remedies comes up. So a winning party can get compensation. But if the other party doesn't comply with the arbitration panel's ruling, the winning party, as it were, can suspend its obligations. So that could involve, for example, as you have an obligation not to impose tariffs, suspending your obligations would mean that you could impose tariffs. So let's say, for example, one party breaches the agreement in relation to transport. There is the possibility of cross-retaliation. So just because one party breaches the agreement in relation to transport, the other party doesn't have to take action in the area of transport. It can cross-retaliate in the jargon. So it could, for example, decide that it will impose tariffs on goods in response to a breach in relation to transport. I'll just say a bit about the law enforcement dispute mechanism. Law enforcement is sort of a separate area. It's an area of non-economic cooperation, and the dispute enforcement here is purely political. There's no arbitration panels. The parties just sit down together and try to resolve the dispute through political means. And there's no cross-retaliation here. So a breach within law enforcement has to be dealt with within that area. It doesn't sort of contaminate or seep into other parts of the agreement. While we're on sort of framework type institutional issues, I'll just say a little bit about termination and review. There are some quite detailed provisions here. There's a general provision that the whole agreement has to be reviewed every 5 years. There's a termination clause which applies to the whole agreement, and the whole agreement can be terminated with 12 months notice. But interestingly, there are also various provisions about review and termination which relate to very specific parts of the agreement. So, for example, in certain circumstances, the trade part of the agreement could be terminated, but other parts of the agreement could continue. But these provisions have to be looked at very carefully, because they can have possibly unintended or automatic consequences. So, for example, within the trade part, there is provision to terminate, but terminating the trade part automatically terminates road transport. So you need to be aware of what the consequences and implications might be. I'll just move on to part 2 now. So looking at quite a broad coverage here: trade, transport, fisheries, and other arrangements. So other arrangements cover things like procurement, digital trade, energy. There's quite a lot in this bit, but I'm just going to say a little bit about trade, specifically trade in goods and in services. So the main thing to note about the goods part, which I think is very well known, it's a zero tariff, zero quota deal subject to compliance with rules of origin. Important to bear in mind that the Northern Ireland Protocol still applies to the movement of goods between the EU and Northern Ireland. So what are the main changes to note? Well, customs controls now apply to UK goods entering the EU and vice versa, although the UK is actually phasing in the controls, and full controls will be in place by the 1st of July. There is bilateral accumulation. So for rules of origin purposes, what's made or processed in the EU is counted as having been made or processed in the UK, and vice versa. So to take an example, if a UK company exports tractors, let's say, to the EU, and half of the components are manufactured in the UK and half in the EU, the finished product counts as 100% UK made, and it benefits from no tariffs. Another new aspect to trading goods is that the parties can now take trade defence measures, so anti-dumping duties, countervailing duties, and such like, in accordance with WTO rules. I'll just say a little bit about services. So the freedom to provide services no longer applies in the EU sense. The service providers are, in essence, subject to the rules of the host state in which they are providing their services. There is a non-discrimination provision, so service providers in the UK are not to be treated less favourably than EU service providers, and vice versa. Just a little bit on professional services. So the default position is there is no longer any mutual recognition of professional qualifications. There is, however, a framework for considering mutual recognition of qualifications on a profession by profession basis in the future. But there are special rules in relation to lawyers. So in certain circumstances, lawyers can use their home state qualification and go and work in the EU or UK, as the case may be. And important to note an interaction with the withdrawal agreement here. So if you were an EU national living in the UK, or a UK national living in a UK national living in the EU before the end of the transition period, and your qualification was recognised, that continues under the withdrawal agreement. That's one of the provisions in the citizens' rights part of the withdrawal agreement. And then finally, on professional services, the TCA includes commitments on mobility for short-term business visitors, intracorporate transferees, and the like. Just say a little bit about financial services, because obviously that's such an important part of the UK service sector. You've heard a lot of talk about equivalence decisions to be made by the EU. Now, these are entirely separate from the TCA. They're a unilateral decision that the EU will make. So the TCA doesn't deal with that. The financial services section leaves a fair bit to the future. So, for example, regulatory cooperation in relation to financial services is going to be set out in a memorandum of understanding between the two parties. So this is one of several examples where the detail of cooperation is to be dealt with at a later date. I'll just say a little bit about level playing field, because that got so much attention during the negotiations of the TCA. So in essence, it's about ensuring fair competition in specific areas. So the level playing field actually covers specific named areas. So these are competition, subsidy, state-owned enterprises, taxation, labour and social standards, environment and climate change, and trade and sustainable development. Now, it's not a one-size-fits-all set of provisions here. They all work slightly differently, so you do need to look at the detail of each one. So I thought I'd just focus a little bit on labour and social standards. So basically, the parties can establish their own level of protection. However, there is a non-regression clause, so the parties can't go below the standards that applied at the end of the transition period if that would impact on trade or investment. In future, if a party diverges significantly and this has a material impact on trade or investment, the other party can take rebalancing measures. So that could include, for example, imposing tariffs on goods. The dispute mechanism here is a slight variation on the main mechanism which we discussed. So it starts off with consultations, but the next stage, instead of it going to arbitration, there's a panel of experts that gets involved, and then you kind of plug back into the main dispute resolution when it comes to matters of compensation and suspension. So the other areas, as I say, are things like transport, fisheries, road haulage, digital trade. I'm not going to go into the detail of those because they, as I say, they are quite specific, complex areas. I skip on now to part 3, which is law enforcement. This is an important area of non-economic cooperation. I'll just flag some of the things that it does. So it introduces a replacement for the European arrest warrant system. It allows for exchange of passenger name records. There's a mechanism for sharing DNA and fingerprint data. The UK can participate in Europol on third country terms, but there is no continued access to the SIS2 database. And as I mentioned before, this area has its own dispute mechanism, which is separate from the rest of the agreement. I will just touch very briefly on the remaining areas. So if we move on to the next slide, there is thematic cooperation. So this involves cooperation in health security. So an example of health security would be cooperation in relation to cross-border health threats, obviously very topical at the moment, and also cyber security. Part 5 is about participation in union programmes. So this allows the UK to continue participating in specified union programmes and sets out the terms of UK participation, how the money will be calculated, the money that the UK has to pay in, how that will be calculated. And one example of a programme that the UK is going to carry on participating in is Horizon, which is the EU Research and Innovation Programme. So then we come on to the protocols and annexes. They are very, very detailed, and I'm not going to go into them in any detail other than to let you know that they are there. And if you're looking at the agreement, you obviously need to look at the protocols and annexes too. I'm conscious there's a lot to take in here and not everything will be relevant to everybody, but if you are interested in finding out a little bit more without having to wade through the 1200 pages, both the European Commission and the UK government have published their own explainers, which essentially summarise what's in the agreement. And I would also commend the House of Commons library briefings. They have published a series of briefings on various aspects of the deal, which are very readable and helpful. So I'll now hand over to Olivier. Thank you.
Well, thank you very much, Indira, and welcome to everyone this afternoon. Before I begin, I just want to let everyone know that if you have any questions, you can ask questions in the question box, and we will take them at the end of this session. So in the remaining minutes, I would like to broaden the discussion a little bit. You've heard from Eleonor and Indira, who've given you an overview of the legal framework and the complexities of the legal framework. But what will the future relationship between the EU and the UK look like? And obviously, this is a very general question, and I don't claim to have an answer to all of the aspects of this question, but I will share a few thoughts as a European Brussels-based lawyer, and I will focus on something that Indira touched upon, which is divergence, or the risk of divergence between UK law and EU law. And to do this, I will focus on the area of data protection, not only because I'm a data protection legal expert, but also because we can use data protection for some interesting examples and to illustrate some of the things that I will say. So to start off, maybe as a general comment or observation, I would say that you don't simply wash off or wash away 47 years of being part of the European Union, and both individuals, citizens in the UK, but also companies have been accustomed to this EU legislation that has applied to them. So citizens have certain expectations, and particularly in the field of fundamental rights and data protection rights. This is certainly something that will continue, and businesses in the UK also have been compliant with EU laws for several decades, and in that regard have integrated a lot of the standards and practices that are in place within the European Union. And so I think to a certain degree, we are likely to see that a lot of these standards and practices, to the extent that they are common between the EU and the UK, are likely to continue. But obviously, we are already discussing about excuse me, about possible divergence between UK law and EU legislation. And I think, well, this is probably going to be a risky path, or to put it otherwise, it does contain some risk for the United Kingdom. First of all, as a very general comment, because now as a third country, no longer a member of the European Union, in order to continue to have access to the single market of the European Union, the UK is expected and will have to comply with the terms of the Trade and Cooperation Agreement, everything that has just been explained to you by Indira. And in particular, what Indira was mentioning about the level playing field, for those who did follow the discussions, well, it was indeed something that was put forward as a key point by the chief negotiator Michel Barnier on the EU side, and in an essential condition to reach an agreement on this trade and cooperation agreement. But looking more specifically at some of the areas where we could see some divergence, and one of those areas is data protection. There have been some recent announcements, and not all these announcements are always very precise, but they sort of give an indication of how the UK government is seeing things, or where it may want to go moving forward. And this contains some risk, because for those who are experts in data protection, or who have been following the recent developments in the field of data protection, you know that under the terms of the Trade and Cooperation Agreement, it was agreed that the European Commission would issue an adequacy decision that would grant a special status to the United Kingdom in order to facilitate the ongoing data flows of personal data between the European Union and the United Kingdom. And so this is an ongoing process, and the European Commission has not yet adopted its formal adequacy decision, or decision which grants adequacy status to the UK. The EDPB, the European Data Protection Board, is also going to issue an opinion before this becomes formal. But what we do know already is that this adequacy status will be limited in time. In fact, there will be a review process after 4 years. And so it does give an indication that the European Union is conditioning this adequate status to the United Kingdom maintaining the same standards and not diverging divergent significantly from the GDPR and the EU data protection framework. And only just recently, EU Commissioner for Justice Didier Reynders also in a speech he was given to the European Parliament also made it very clear that he would, or the European Commission would not hesitate to suspend the adequacy decision if it finds, or after this 4-year process, if it finds that there are some significant divergences. So what this shows is that Europe will be watching, or if to put things otherwise in a different metaphor, there is a sort of Damocles sword above the UK's head, that in order to continue to benefit from this adequacy status that will facilitate data flows between the EU and the UK, the European institutions will be watching, the European Parliament, the European Commission, and also the EDPB. And there have been already some discussions about the risks of the UK becoming some sort of a backdoor to onward transfers of EU data to other third countries, for example, the United States. And we know the whole discussion and the tensions that there are currently between the EU and the US on transfers of personal data. And another risk that that divergence could create is a risk of court actions. Indeed, it's not impossible that if there are signs or even elements that substantiate the fact that the UK GDPR or the UK data protection framework is divergent from EU law, this could encourage or push some EU privacy associations to bring court actions before the European courts, and in particular before the Court of Justice of the EU, in order to either have the UK adequacy decision suspended or annulled or repealed. And we know that this has happened in the past with our precedents in a different context, but with the Safe Harbor and more recently with Privacy Shield. And so we know that some privacy associations are very active and will also be watching. Another element that I think is important in this discussion is the continued relationship between the regulatory bodies. Now, as you probably know, the Information Commissioner's Office is no longer a member of the EDPB, the European Data Protection Board, as a consequence of Brexit. But that is not to say that the two instances or regulatory bodies will no longer be cooperating with one another, and it's even likely, I would say, that the EDPB's guidance will continue to have some sort of influence over the positions and the guidance of the ICO. We know that the ICO has been an extremely important and very active member while it was still a member of the EDPB, and will continue to play an active role in the European data protection scene. And we have seen at a very practical level in some areas, for example, in the context of data transfers, where the ICO has recently has had to start adopting its own regulatory guidance notes or documents, that it has relied on the existing one of the EDPB. So rather than reinventing the wheel entirely, it has taken some of the documents that already exist and that were adopted by the EDPB and amended them and implemented them under the UK framework. And we've seen this, for example, with binding corporate rules to allow companies to file applications for binding corporate rules before the ICO. So that is an example of where EDPB guidance continues to have some sort of influence over the work that is carried out by the ICO. But I think that more generally, the ICO and the EDPB will continue to work together and will try to a certain extent to also to maintain some sort of consistency in their approach, in their interpretation of data protection law, and there will be some sort of alignment, I believe, between the ICO and the EDPB. one aspect that I think is worth mentioning too is how the market is going to react to all of this. Now, this is maybe a difficult aspect to assess, because it's always difficult to anticipate how the market is going to react. But what we do know is that market players, they do like some sort of legal certainty and consistency as well in especially in compliance areas such as data protection. And to the extent, once again, that the UK and the EU can maintain some form of standardization or harmonization of the data protection rules, I think the market will react very positively to this. Very probably the EU will continue to be to have a strong influence in the field of data protection beyond the EU borders. I mean, we saw this when the GDPR came into force, that it had some sort of a global there was a global impact, and the the impact was quite significant outside of EU borders as well, and so to a certain extent, we can expect that companies in the UK will continue to look at what is happening in the EU, at the changes and developments in the EU, and will also try in a way they implement their privacy or data protection compliance frameworks to integrate EU law, even though they might have their businesses located in the UK. And particularly if the EU continues to impose some very high standards for data protection, then some companies, particularly the multinational organizations, are likely to continue to use the EU GDPR as their common standard, and will probably want to apply the highest threshold possible for data protection, and this may therefore have some sort of influence also over the data processing activities in the UK. So as we can see, different areas where EU influence may continue to play an important part. In the remaining minutes, I'm conscious of time here, I will also just finish by pointing out that the continued influence of the judicial system, even though Indira mentions that the UK will no longer be subject to the rulings of the Court of Justice of the EU, but it's worth noting that the UK continues to be a member of the European Convention on Human Rights, and in that respect, the rulings of the Court of Human Rights in Strasbourg will apply to the UK. And also, it's worth mentioning that the Convention 108 of the Council of Europe also continues to apply to the UK. And for those who know a little bit about the history of data protection, well, this was the very first sort of data protection treaty in Europe that was adopted, and which laid down the principles for data protection that are still applied today. So with that, we shouldn't neglect the continued influence that the European courts may have in the UK. With that, I'm conscious that we have just a couple of remaining minutes left. So I don't see any questions in the chat box. So I don't know if there are no questions, then we will perhaps, well, if anyone does have questions, you can reach to us by email, and we will be glad to answer those questions for you. Maybe if we move to the next slide, this is just to let you know that if you are interested and want more detailed information on retained EU law, you can find the book that Eleonor and Indira wrote, and we've provided here some links for you to find this book, and which will give you a lot more information about how this all works. And with that, yes, I would like to thank you all for participating to this webinar, and hopefully you have found it useful. And once again, feel free to reach out to us if you have any questions. With that, I would like to wish you a nice end of the day, and thank you again very much. Thank you, Eleonor and Indira.
Thank you. Thank you very much for joining us.
Bye-bye.